Hello everyone, so today we'll be going over the trial covering the Grammy Award winning rapper Young Thug and his associates. In today's episode, I intend to bring you viewers up to speed with the trial against Mr. Jeffrey Lamar Williams, also known as Young Thug, and fellow rapper Gunna, also known as Sergia Kitchen, amongst 28 other people who were charged in the Georgia's RICO Act. Now, the charges are all related to gun-related activities dating all the way back from May 9th, 2022. Now, this is when the charges were actually first filed, I believe. Now, for allegations against YSL, the prosecutors argue that Young Stoner Life Records, or YSL, or Young Slime Records, is actually the front for a gang. And they say Young Slime is the official name of this gang. This gang was involved in criminal activities like M1 and drug dealing. Young Thug is accused of being the leader, the ringleader, the president, the head honcho, and he's indicted in over 36 criminal acts. Involvements and arrests. Young Thug was linked to various criminal activities involving renting a car that was used in a murder, and both he and Gunna were denied bond many times after they tried many times to get it. Young Thug's statements and the DA's response. A recorded message from Young Thug, released by himself, claims that he's a target for his art. He believes that he was free to express himself as an artist, but he now sees that as a rapper, that is not the case.
This isn't just about me or what I feel. I always use my music as a form of artistic expression. And now I see that black artists, rappers, don't have that freedom.
The Fulton County DA, Fannie Willis, emphasizes her focus on targeting gangs to keep the community safe, no matter what your social status is, no matter how wealthy you are. Now remember, there are also rumors of her involvement in this case and the reason why she's truly behind it, but that was not discussed today.
I've made no secret about it, nor any apology that as the district attorney of Fulton County, my number one focus is targeting gangs. And there's a reason for that. They are committing conservatively 75 to 80% of all of the violent crime that we are seeing within our community. And so they have to be rooted out of our community. I said just a week or two ago, it does not matter what your notoriety is, what your fame is. If you come to Fulton County, Georgia, and you commit crimes, and certainly if those crimes are in furtherance of a street gang, that you are going to become a target and a focus of this district attorney's office, and we are going to prosecute you to the fullest extent of the law.
Plea deals and admissions. Here we have a recording of Gunna, who took an Alford plea, maintaining innocence but acknowledging likely conviction at trial.
Have committed crimes in furtherance of the gang.
Yes, ma'am.
And do you acknowledge the following statement? I recognize, accept, and deeply regret that my talent and music indirectly furthered YSL the gang to the detriment of my community. YSL as a gang must end. Is that your statement or acknowledgement?
Yes.
He pleaded guilty to one count of conspiracy to violate the RICO Act and received a 5-year sentence with conditions. Other defendants also took plea deals, but not all were cooperative. There were also jury issues and courtroom drama. The jury selection process faced many challenges, including uncooperative jurors, delayed starts, and courtroom disturbances. Some of these disturbances included contraband in the courtroom and a juror being held in contempt.
The state's offer for Mr. Mender as to count 1 is 16 years to serve 1 year commuted to time served with a balance of 15 years on probation.
He still maintains a not guilty plea.
There's one thing about trials, it's uncertainty. You don't know what's going to happen. So you got to beat 4 counts. If you don't beat them, what will happen is under this A and C recidivist statute, I have to, under the law, sentence you to the maximum sentence.
As the trial approached, there were various pre-trial motions and incidents, including arguments about the admissibility of song lyrics as evidence of criminal activity. The judge conditionally allowed some of these lyrics as evidence.
Part 1, the conspiracy. As associates of the enterprise Young Slime Life, hereinafter YSL, the defendants conspire to associate together with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. In furtherance of the conspiracy, the defendants engaged in the activities enumerated herein. The objectives of the conspiracy included but were not limited to preserving, protecting, and enhancing the reputation, power, territory of the enterprise through acts of racketeering activity including murder, assault, and threats of violence. Preserving and protecting and enhancing the reputation, power, and territory of the enterprise by posting of messages, images, videos, and songs demonstrating allegiance to the enterprise and a willingness to engage in violence on its behalf. Maintaining armed individuals ready and willing to preserve, protect, and enhance the reputation, power, and territory of the enterprise through the use of violence. Obtaining money, weapons, and other property through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs. And obstructing law enforcement investigations and court proceedings through witness intimidation and attacks upon law enforcement officers.
And finally, there were 18 jurors selected for the final jury.
Of Judge Glanville chastising a juror. In early January, the juror was called in for potential service and was supposed to return to the courthouse the following Monday, but instead, juror number 64 didn't show up. Turns out she was on a business trip in the Dominican Republic. She claimed that she tried to notify the Jury Services Department about the trip, but was apparently unsuccessful. She told Judge Glanville that she didn't even know she was in trouble until deputies showed up at her grandmother's house looking for her. Well, Judge Glanville held juror number 64 in contempt of court, but instead of the usual $1,000 fine and up to 20 days in jail, he had a bit of a different idea.
What I then want to do is, in order for you to satisfy your contempt, I'm going to commute the 20 days and require you to write a 30-page paper on the importance of jury service. Here's the criteria. You'll have to do APA style. You're going to have to use at least 10 primary sources, 10 secondary sources. You're going to write at a minimum, the history of jury service, who could not serve on a jury, because that's very important, because years ago, people that look like us couldn't serve on juries. It was prohibited. I want you to talk about jury service in Georgia and discrimination at a minimum, those 4 things, okay? I am going to give you a date 3 weeks hence that paper needs to be submitted to me electronically. And we're gonna run it through a plagiarism checker. You gotta write it yourself. And then you're gonna come back and talk to me about it.
With the other people in the courtroom, because if you think about it, there are a lot of defendants and attorneys all in one room, and it's gotta be hard for the judge and the deputies to monitor everything that's going on. Doesn't mean that they haven't caught on to several issues. For example, the judge has had to address the defendants and their attorneys multiple times in January alone because of contraband. Someone allegedly smuggled marijuana from one of Young Thug's co-defendants and a pair of shoes. Another co-defendant's mother was arrested for trying to sneak tobacco products and rolling papers in a bag of clothes. And yet another contraband incident ended up halting the jury selection process for an entire day. Here's what Judge Glanville had to say about it.
Had yet another instance of alleged contraband being introduced to our space. And as a result of that and a subsequent investigation, one of our inmates unfortunately had to go to Grady Hospital. The other thing I would just invite counsel to talk with their clients about, I know I've mentioned this 3 times now, what is considered to be acceptable behavior. This is the 3rd time that we've had contraband introduced into this in this space. The court's concern is that this may pose issues to them remaining and being present in this space.
But here's something to think about. We started with 28 people listed in the indictment, but due to plea deals, cases being severed into other trials, and for a whole list of other reasons, we are now down to just 6 defendants actually going to trial, including, of course, Young Thug. So what has happened since jury selection started? Well, Judge Earl Glanville has had to deal with some pretty blatant law-breaking right in the courtroom. At the end of January, one of the men charged as part of this huge gang indictment filed a formal complaint against deputies for how they treated him following an apparent in-court drug deal. Yeah, Khalif Adams was seen on camera walking up to Young Thug and handing him something. Prosecutors say it was a Percocet, brand of oxycodone. And to his credit, Young Thug immediately handed the pill to law enforcement. Adams was taken to a holding area where his attorney alleges that Fulton County deputies searched him, but also tased and assaulted him. Adams ended up going to the hospital. The complaint also alleges that the deputies didn't have their body-worn cameras turned on during the interaction. Adams is already serving a life sentence for murder, and he's charged with conspiracy and attempted murder in this case. But given what happened in court, he was also hit with fresh new drug possession and obstruction charges. Let's skip ahead now to April, where there was another courtroom disruption. Defense attorney Anastasios Menedis represented Miles Farley. And one day, Menedis was undergoing a routine check of his bag when officers found a bottle of prescription medication and arrested him. As officers closed in on Menedis, he allegedly went to toss his phone to another attorney. It ended up hitting one of the deputies. So he was charged with simple battery on a law enforcement officer, possession of pills not in their original container, and disrupting courtroom proceedings. Menedis got his own attorney, who said that the battery charge was dropped, but Menedis was released from the Fulton County Jail on a $5,000 bond. That left it up to Judge Glanville, who had to decide what to do with Menedis' client, Miles Farley.
It has been brought to the court's attention that Mr. Menedis has been taken into custody this morning. And I'll let that process kind of play out. However, due to that particular issue, the court's going to go ahead and sever Mr. Farley on its own motion.
And that wasn't the only time that Mr. Menedis had been in trouble with the court. Now, you see, he had been held in contempt another time, reason not entirely clear, and he was ordered to pay a fine of $250 and buy all of his colleagues lunch.
You were held in contempt, young man. And if you want to revisit that again, we can certainly open it up. But I satisfied your contempt by you paying $250, which you did, and I have a receipt from that of your choosing, which that was done to Miles College. I have that receipt here. And the other thing was to purchase lunch for each of your attorney colleagues in this case on Friday, March the 17th, from Jason's Deli. So prong one's been settled. Prong two was you're supposed to buy your colleagues lunch by that date. Mr. Menendez, this was in satisfaction of me not sentencing you to jail for 20 days. So if that's the case, well, then I will revisit the basis for your contempt. But I thought that, and in fact, I'll have Ms. Weaver go ahead and pull that order, pull the part of the record. But I did, in fact, I did not hold you in, I did not go ahead and sentence you to the 20 days. I said that this would satisfy, once you apologized, I said you can pay, because remember, you were going to do I was going to have you do a report as well, or a written product. I was also going to, but instead of doing that, we settled on the $250, and we settled on your buying lunch for your colleagues on the 17th of March. So that was my understanding.
My understanding was that I apologized and that I was doing that to sort of show that I was serious about the apology. I'll still buy the lunch.
And that will satisfy this court's concern, okay?
So in conclusion, guys, this is everything we know about the Young Thug trial prior to the opening statements, which began November 27th of this year. Thank you for watching today's video, and I'm gonna see y'all in the next one. Now remember, if you like my drawings, if you like my art, you could always subscribe, share, comment, follow me over on Instagram, TikTok, or any other social media that you may use.
If it comes out that I've represented, I'm just making this up, Mr. Greer on a murder case, I'm going to have to then either become a witness, which I do not want to do, or call somebody like from the clerk's office or the Honorable Judge Newkirk or somebody to explain, no, I only represent him on the appeal, it was successful, I don't represent him, and to show it did not have anything to do with this case. That goes for everybody. I was not involved with representation with anyone on this current indictment.
Greer was clearly pleased with Mr. Steele's representation as reflected in the song Can't Tell Me, in which it stated on the phone with Brian Steele, talking about the case, yeah, he told me slow my roll because he can get this erased. Also featured in the song is Kendrick, aka Yak Gotti, and the lyric is sung by Greer. Anyway, this evidence shows that multiple co-defendants and potential witnesses that could testify, we don't know that yet, may have feelings and or relations with Mr. Steele that the state's entitled to explore on cross-examination, should they choose to testify. So at this time, a ruling such as the one Mr. Steele asked for is going to be premature.
It's going to be very fact-specific. So I'll hold on ruling, and I'll make a ruling specific to what is presented, okay?
Thanks again for watching today's video, and I'm going to see y'all in the next one.